They can just add their student numbers to the chat for attendance.
Okay, thank you.
Okay. You are all good. You can go on.
Oh, thank you.
Okay.
Okay. Hi, good evening, Tsakani, Lizzie, and guest. Can you all hear me?
Yes, I can hear you from my side. Good evening as well.
Evening. Hi, welcome.
Hi, everyone.
Hi, Tsakani.
Brian, the other person's name is Queen.
What?
Queen. Yes.
Queen. Okay.
So she's the queen tonight. Maybe
Right, she is. Yes, we're in the
have a
company
good
of royalty.
rest.
Yes. Hi, Queen. Welcome. Okay, guys.
Hi.
Hi. Listen, it's 5:32, so I normally wait a few minutes for people to turn up because what inevitably happens is as we get going, people start joining us. So would you guys wait for a few minutes?
No problem.
I'm happy to wait.
Yes.
But well, we give others a chance.
Yeah,
There's
true.
always some issue.
Okay,
You know,
can
if it's not connectivity, it's work issues and late transport issues. So we must consider that. Okay, so
No,
let's just
give him a
okay.
chance.
Okay, five or so minutes, huh? We'll see.
Okay,
Couple
cool.
of minutes. See you.
Right, thank you.
All right, good evening. We're back. We've waited a good few minutes for people. And okay, I think, okay, Aisha has joined us. And the others, I think there was, I don't know if somebody else has also come, but welcome to this evening's class. So who is here, guys, for the first time? Who is the first time? Okay, you and
I'm here
Queen.
for the first time.
Right. Okay, welcome to the two of you. Aisha, I know has been here before. Lizzie, I think, has been here as well. Aisha, what was that? What were we doing last week, Monday?
Suspension.
We were busy with unfair labor practices, weren't we?
Yes, the suspension part, the punitive suspension and precautionary suspension.
Right. We had that example, that question. Can you remember the question?
No.
If not, I'll put the question up in the chat box.
Okay.
So that you can see it for the benefit of everybody. It's so hard to see the way the highlight.
I think we ended off with whistleblowing, the Protected Disclosures Amendment Act.
Right. Okay. Let's deal with it very quickly so the others can also benefit from it. Can you guys all see this here? I've shared my screen. You see this question here?
Yeah.
Yes, yes, we
You
can.
all see it. Okay. Let me try and make it a bit larger in the font if we can. Is that better now?
Yes, that's
Much
better. Thank
better.
you.
Yes. Okay, guys. Let's do a quick recap. We had this question about Gerald. He works with this construction company, and the employer is required. Gerald's employer is required to deduct money from every employee's salary and pay it over to the unemployment insurance fund. But now Gerald has found out that although the money is taken from the salaries, the employer deducts it from the salaries, he doesn't pay it over to the fund, but he rather uses that money for personal expenses. And Gerald finds out about it and he lodges a complaint against his own employer at the Department of Labor. And because of this happening now, the employer finds out and the employer decides to suspend him, pending investigations of his acts. Okay. So we did discuss this question a bit. The first question was, do you think it was justified of Gerald to lay a complaint against his employer? And I think we covered this. Eh? We said, what did we say? Aisha, can you recall what we said? Yeah.
Let me just think.
So we're dealing with suspension, which is, putting you off work, right? And then we did mention that you get two kinds of suspension. You get like what we call precautionary suspension, and you also get punitive suspension. And precautionary suspension is normally imposed when the employer wants to investigate a matter and there appears to be some proof against you, but there must at least be some kind of, doesn't have to be perfect proof, but at least what we call prima facie proof. It appears that there's information that, indicates that you could be guilty of something. And secondly, there must be a reason that, that he should not be at the workplace. That is the general requirements to put a person on precautionary suspension. Okay. Punitive suspension comes up at the end of a process of a disciplinary hearing again, where they've charged you. Now leave that aside. We come back to the precautionary. There is information coming out that you did something wrong. In this example, Gerald did this now. The employer puts him on suspension, which is presumably precautionary suspension. And then the employer is going to investigate it, right? So I gave you what requirements are there. There must be prima facie proof at least, and there must be a reason why, a good reason why you should not be at the premises, at the employer's place. Okay. Punitive suspension is where after they've now charged you, because during investigation they will collect evidence, they will take statements from witnesses, they will gather documents and other evidentiary material, and then they will sit, okay, are we going to, did this person break a law now? Not a law, but a rule in the workplace. And then they will decide to charge you, and then they will charge you. They should follow a process, disciplinary hearing, and if they find you guilty, then they can impose a sanction. And if they one of the sanctions one person could impose is punitive suspension. Okay. Now, suspension normally is done with pay. When you suspend somebody in a precautionary suspension, it's normally done with pay. And secondly, you know, if it's punitive, it means normally that will be without pay. And obviously people would want to take issue with that. So, but we come into other questions here now. You know, was Gerald justified to lay the complaint against his employer? We did say yes, because, you know, this is a prejudice to Gerald and the other employees at work, that they are suffering now because the employer doesn't pay over the money to the insurance fund, unemployment insurance fund. And as a result, they can't claim, or they will have difficulty in claiming unemployment insurance, you know, unemployment benefits if they should become unemployed. So we also mentioned that there's another law over and above this known as the Protected Disclosures Act. All right, Aisha?
Yes.
You as a whistleblower, if you can report your employer for committing crimes. Now, the Protected Disclosures Act speaks of two kinds of disclosures, what we call a protected disclosure and a general protected disclosure. You know, like a specific protected disclosure and a general protected disclosure. So the specific, protected disclosure is when it involves high-ranking employment in government. Okay, Patricia de Hoo wanted to, blow the whistle on something going on, the arms scandal, here in Cape Town, and she was afraid that she could get dismissed if she were to now, by the party, if she were to now do this, beyond without the authority or something. Okay? So, protected disclosure and a general protected disclosure. So protected disclosure is involving high-ranking officials like ministers and legal advisors. And, it's a disclosure that you make. They both are disclosures, but both are, in different contexts and in different situations. First one is like the violation of a crime, like, oh, there's corruption going on. They're supposed to comply with the procurement rules, but there's one official that is ignoring the rules and giving, as we can all see, has actually happened in the last few months, the COVID scandal. Okay, so if you know that if you are going to report, or you are going to, let the authorities know about it, then you're going to suffer prejudice. In fact, what will happen to you, Aisha? What is it, that thing called, the term used in the Protected Disclosures Act? Can you recall?
Is that detriment?
Yes, occupational detriment.
Yes.
That's it. So there's two things that you need to, you need to consider. Two important legal terms used in the Protected Disclosures Act. What you're saying is, I'm going to make a protected disclosure, and if I do, then I will suffer an occupational detriment. So the protected disclosure, we now learn that there's two parts to it, a specific protected disclosure and a general protected disclosure. The one is not, the one has to deal with crimes in the workplace, okay? Because one can't also accuse people without proper evidence, all right? One must also be reasonably sure, because what happens if Gerald now learns about this going on, but then he's mistaken? Gerald thinks the employer is actually, spending the money on, his personal expenses, but what happens if he's mistaken about it now? What will happen to him now? Because isn't talking outside of your workplace also a violation of your employment agreement? That you must respect the privacy and the information that you come across. You must act in good faith with your employer, right? And if you say things like that, you could bring your employer into disrepute. And what could happen to Gerald? Gerald could maybe even face a disciplinary hearing. So when you make a protected disclosure, the information should reasonably be true now. You must believe at least that there's some evidence and that you believe it to be reasonably true. But if you start to suck things out of your thumb and you start to, you just base it on pure suspicion, which is not a reasonable suspicion, there's no evidence even, then it's a bit dangerous to make those disclosures. Okay, so in his case here now, the question was that is it justified? And it will all depend on the kinds of evidence that Gerald has. He learned that the money is taken from the salaries, but it's used not to pay over to the Department of Labor, but it is used for his personal expenses. So Gerald should be sure of himself at least. Right? Gerald should at least get some kind of evidence to confirm that before he starts to report that. Okay, but if it's got evidence and all he needs is to show that it is reasonably true, a reasonable belief that it is true. Okay, and then what is an occupational detriment? An occupational detriment is where you can show that if I were to disclose, make this protected disclosure, then I will suffer some kind of prejudice. I'll suffer some kind of problem. They will fire me, they will demote me, they will transfer me, they will lower my salary, they will demote me. So all these things are what we call occupational detriments. And often in the workplace, many people want to speak up against what's going on in the workplace. And when there's something that is not right or legal, so they they should get some kind of this protection when they speak up against it. So this is what this term whistleblower means, right? Someone who blows the whistle on what the covert and bad and illegal activities going on inside the organization. You may get specially protected. Are there any questions on this, guys? Queen and whoever is new here, Sakani, you're welcome to ask questions, eh?
No, I'm still following nicely.
Okay, cool. So that's what Gerald could do that. So the question was, Gerald, was he justified? Whether he was justified or not would depend on the kind of evidence that Gerald has. Okay, if he had the evidence and this was fact and he can prove it, then of course he would be justified, right? Because that is it's a criminal act not to pay over that money to the unemployment insurance fund. There will be consequences for the employer. Okay. It's a different case where the employer, if your salary is 5,000 rands a month and your employer says, I'm not going to deduct the money, your UIF, I'm going to pay you everything. Okay, it's a bit different. So you must be careful. You can't just report him for that. Although it's not the ideal thing to do as the employer must actually take the money and pay it over, but not use it, of course, for personal expenses. Do you think it is fair for his employer to suspend him for what he has done? Hey guys, was Gerald fairly suspended here?
I'm in between.
Okay,
Yes,
yes.
I think it ties back to also what you touched on. Depends on what was, if whatever he reported was based on facts, or if he was just sucking out of his thumbs as well. So it depends on the evidence which was, which obviously sent through to the Department of Labor.
Perfect, perfect. Right. So we have to judge everything on the merits.
Hello, I'm losing on my side. I think there's a network problem.
Okay, I'm back again. I was out for a moment. I'm back now. Our internet just went slow. Um, so absolutely right that it will depend on the evidence. I agree with what you said there. You know that it all comes down to evidence, because you can't just go badmouth your employer without evidence, right? You can't badmouth anybody for that matter, let alone your employer, right? You can do that, but then you'll suffer consequences. Any further questions on that? Now, what happened if the question doesn't give us further facts, right? So, is there any recourse for Gerald if Gerald believes that, look, I don't like what you did to me? Let's say he was put on not punitive, not punishment, not after the disciplinary hearing. Let's say he was put on precautionary suspension, right? What recourse is there open to him? What can he do if he believes, no, this is not right? Is there anything that Gerald can do? Okay, so a number of scenarios can actually play out here, guys. Normally suspension is, you must prove that there must at least be some kind of prima facie proof against you. There mustn't be a reason for you to be at work. Okay, so there must be a reason for the suspension, a good one. Number one. Number two, they must also hear your side. They can't just make the decision. They must give you an opportunity to say, look, we are going to put you under suspension. Here's a notice. If you have any, input from your side, or you wish to add something why we shouldn't suspend you, you should let us know. But we've got evidence, prima facie evidence, that suggests some charge against you. And if you continue to be at work, you could make trouble, you could make the investigation difficult, you could tamper with evidence, you could try and influence witnesses. So it's better if you're not there. Okay, again comes down to the question of evidence. But in terms of section 186, subsection 2 of the LRA, the Labor Relations Act, an unfair labor practice is any unfair act or omission that arises between an employer and an employee. I'm going to miss subsection A and I'm going to move to subsection B, involving the unfair suspension of an employee or any other unfair disciplinary action short of dismissal. All right. So he could challenge this. He feels it is unfair, and you will have to prove those things. Whether it is fair will depend on the facts. Okay, which we're not being told about, but it's a question of the evidence against you. What I would like to hear from you here is why you think it is fair for his employer to suspend Gerald. Could be the fact that the employer must show that. What do you think the employer must show to have suspended Gerald like this? From an evidence point of view, what do you think the employer had to show for suspending Gerald like?
I think it is, with regards to is a prima facie, I don't know if you spell it right.
Prima facie, yes.
Okay, reason to believe that the employee has committed a serious misconduct.
Right.
And there is some objectively justifiable reason for excluding the employee from the workplace.
Right. So in this case, what would that be?
How do you mean?
You said there must be prima facie proof and there must be objectively justifiable reason for him not to be at the workplace. So what would that be?
If the person is going to tamper with the evidence or
No, that is for him not to be there, but like what evidence is there that that the employer will have to put him on suspension? What would be this prima facie proof?
it will maybe breaking of a rule or
not enough. It will have to basically be that we've got evidence, prima facie, we must still prove it. But there's evidence showing that Gerald actually laid a false complaint.
Okay.
All right. Wouldn't it be? Because now he would have got to report the employer for something. Now the employer can say, oh, he did that, and he's saying that the company's spending the money on what is it? Personal expenses. Yeah. So what the employer knows it's false. Now the employer can say, well, it's a lie. We don't do that. The employer's got proof that all monies that were deducted that were paid over, for instance. Right. So still the employer can't, just punish him. The employer must first investigate the matter. You understand? Even though the employer's got prima facie evidence, the employer must first make sure that, okay, you know what, this was a bad thing you did. You went to go report me or the company, but we never did that. So now look, that's prima facie. Let us investigate this. Let us see now. He's saying that. Okay, there's no proof of that. Where's the proof of that we're using the money for personal expenses? So that would be prima facie proof. If the employer's got evidence to show that they never did that, or evidence that they did pay the money over to the Department of Labor, then they can start investigating. They would be justified in suspending him, But now also the other thing is, why do they have to suspend him? Even if they've got that proof and the proof is secure, then what other reason? There shouldn't be a reason for him not, to be there. So that's the other leg of the suspension rule, that you can't suspend the person. Either you've got the prima facie proof that you did something wrong, but it may not affect his, reason for being there. He can still be there. You understand? So you need to look at this thing like from all angles. Are there any questions on this, guys?
Yes, I have one, please.
Just 1 second. I'm coming. Yes.
Oh, can I go?
Please.
All right. So you're saying that there has to be grounds on why a person would not be allowed to be at the office, particularly for the nature of what happened. So he went and falsely accused the employer of having done something. I think there are some company policies that restrict or rather are against such actions. So would we need to take that into account if maybe the employee contract has a clause in it that says that you cannot go and badmouth or publicly speak about the company without the company's permission or something like that? Would we have to take that into account as well?
Yes. Right. Okay, very good point. Thank you. See, as you're going to learn, and I'm sure some of you already know that in employment law matters, an employer must have a policy on almost anything and everything almost that governs the work relationship. All right? Going on leave, there must be a policy on that. Benefits, there must be a policy on that. Disciplinary action, there must be a policy. Sexual harassment, there must be a policy. Labor practices and grievances, there must be a policy. Right? They must have policies on so many things in the workplace so that there can be fairness and they don't treat one better or different to the other. So you rightly say that some places do have policies, some of them don't. Right? So when you don't have a policy on a particular matter in your workplace, then the law will read a reasonable policy into the matter. will apply what is reasonable and fair according to guidelines of the ILO, the International Labour Organization, right? Which is the RA.
Hello.
Are we back? Sorry
Yes,
about
you're
that.
back
I
now.
can hear you. Yes, can you hear me? You can.
Yes, we can hear you now.
Taking into account policy is where your starting point should be. But now we must remember that not all policies of employers are compliant with the principles of labor law. That is another question. Okay, so sometimes you sign contracts, sometimes there are policies that the employer puts in place, but sometimes those policies may not be in line with the principles of the LRA. And that is a time one can consider a policy and then also challenge the policy itself. And say, well, the policy is not right. Okay, we're agreeing on this and that and the other. We must go according to the policy, but the policy should be compliant with ultimately the constitution, but of the country, but it should comply with all the other labor laws. So
Okay,
yes,
makes sense.
all right.
Thank you.
Is that clear? So we're going to come across issues like that all the time now as we continue in other areas of labor law. Okay, dismissals, sexual harassment policies, unfair labor practices, grievances, and that is why it is good to have it in the workplace. Can you still see my screen? Yeah, am I still sharing my screen with you? Yeah.
Yes.
Yes.
Okay. Do you think, it says, Gerald, this is the third question. Do you think Gerald should be protected from reporting his employer in cases where his employer doesn't comply with the law?
Yes.
Yeah.
Absolutely, eh? Absolutely. Right, because this is the thing that people are so frightened to lose their jobs that they rather turn a blind eye, or they don't care for it, or they're afraid. And now the law is coming to you, help you in terms of the Protected Disclosures Act. Okay? And there's protection for specific protected disclosures and general protected disclosures. Okay? I mentioned the specific protected disclosures are those things, criminal acts specifically prohibited in terms of a law, or involving high-ranking people like ministers and state officials of high rank. And the general disclosure is we just generally bad behavior, or conduct that is wrong, as long as it is reasonably true. All right, then or at least you believe it to be true. And you must be reasonable in that belief. Then you could rely on the Protected Disclosures Act. Okay, that you will sign, and you must prove also, if I do this, I was threatened, I mustn't tell anybody, and if they warn me, if they find out that I've reported it, then I will gonna lose my job, or they're not gonna cut my pension, whatever the case may be. Okay? That is the occupational detriment. Any further questions on this, guys?
Yeah. No, I mean, no questions.
Okay. Okay, then there's another little exercise. Did we do this one properly last week, Aisha? This was this question here now. Try and get the font to your home. Okay, so this is a different question now. I think we just started it, but we didn't complete it, perhaps. Kylie was employed as a store manager at the local supermarket, but was recently demoted to a general supervisor at the same store. Her demotion led.
But it's
Sorry?
fine, we can do it again with the others. We did this one before, Gerald.
Is it? Oh,
yes,
I see.
But it's fine, we can go.
Okay, no, but there's more to cover. There's a lot. Fine, all right. Okay.
We can
Let's
just
see.
go through it and you can just explain to them again. Just so that they know that example.
It's good for everybody's benefit.
Yes.
You know, what I wanted to tell you guys and remind you about is the one-on-one sessions. Okay, are you aware of the one-on-one sessions? Is a form that you can complete. You can pick that is book a one-on-one session with your facilitator. Okay, so over and above these Monday night classes, does anybody here do LLW2602?
Yeah, I do that.
Who's that?
Basa.
Okay, you do that. Okay, have you
Yes.
been to the 2602 classes already?
Yes.
Okay. So that is tomorrow night. But now, you guys, if you're having difficulties with parts of the work or you need some assistance, then you click that form, that session form there, and you request a session, and I will set up a session with you, you know, for up to 30 minutes or so, and then you can, you know, get specific attention and help and assistance. Okay. So take advantage of that. Not every day that you get that kind of assistance. You know, it's a year, not for a limited time period, you know, before the exam. And I would suggest that if you wish to make use of it, rather book now, you know, your sessions that you need and you want, rather as you get closer to the exam. When is the exam coming up, by the way?
I think it's the 18th of November.
So, you know, I don't want a few days before the 18th of November, people are, you know, queuing. So I would suggest that you guys, you know, make use of that form, okay? And you can get extra assistance. So we book a one-on-one session with the facilitator. So here we go to this question about Kylie. Kylie was employed as a store manager at the local supermarket, but was recently demoted now to a general supervisor at the same store. The demotion led to a dramatic pay cut, and she has been struggling to make ends meet ever since. She suspects that the employer's conduct may be found to be an unfair labor practice, and she decides to refer the matter to the Ccma. Okay? Do you think Kylie deserves to be compensated for the amount of money she lost as a result of the alleged unfair labor practice?
Okay, sorry, from my side, I think there's a lot of things we need to consider. For example, when she was demoted initially, did she actually consent to the demotion, or is it something which was forced upon her? If it's something which was forced upon her, then that would be unfair labor practice, and then she can get recourse on that. But then if she consented, then that's something else altogether. Because also the employer needs to provide reasons for the demotion. Was it justified in essence? Just my 2 cents.
No, brilliant. I like that 2 cents. It's actually worth more. Maybe like a 50 cents or something. Or 5 rand. No, it's good reasons, because we're dealing with, you know, if you look how the term unfair labor practice has been defined in the Labor Relations Act, it says here that it means any unfair act or omission that arises between an employer, any unfair act or omission that arises between an employer and an employee involving A, unfair conduct by the employer relating to the promotion, demotion, probation, excluding disputes about dismissals for a reason relating to probation, or training of an employee, or relating to the provision of benefits to the employee. So specifically mention demotion, and then we must understand what is demotion. And I like what you said, that it cannot be done arbitrarily. You know, the minute you agree to something like that. There was another class I had, you know, not this labor class, another labor course, LLB students, where there was a student who, you know, had a problem. He said that there was the employers are forcing them to sign almost, you know, basically agreeing to terms.
We lost you for a few minutes. Are you still there? I can't hear anything.
Yes, I'm here. I'm here now.
Okay.
You're right. Can you hear me? Okay. Yeah.
Yes, I can hear you now.
Okay, good, good. So, you know, this one the person, people sign. Can you hear me?
Yes, we can hear you.
Yes, now we can hear you.
Now.
Hmm.
We can't hear anything now.
Okay. Is everybody still there?
Yes.
Oh, thank goodness. Sorry, guys. You know, it happens. It happens like that. You know, the internet. I mean, I've also have kids that are fighting with me. They are playing games on the internet, and I must really, just cut the internet cable because it's slowing me down. Where were we now? We were talking about this lady Kylie now. Okay, that thing up again. Yeah. So you're absolutely right. When a person, I was giving you an example about another student where the employers are in a way trying to twist the employee's arms by saying, look, you need to sign new contracts now and the new contracts basically mean that they get less money, and it amounts to a demotion. And if they do not refuse, if they refuse to agree to it, you can't impose it, right? You can't force people to it. As you said, there must be a reason for it. Okay. The one way canvas a demotion is probably through another way of dismissal known as operational requirements, where you say that, look, the economical situation of the company is not so good, because this is what those guys were told. That, well, okay, if you're not going to sign that you're going to accept the position, then we're going to have to unfortunately make this position redundant, because due to operational reasons, we can't continue paying people at this level. But you can't automatically do that. You're going to have to do that under an operational requirements exercise, where it involves multiple consultations with employees and the employer to investigate all ways that a company can still continue to maintain employees, including paying them less. Okay, and it might just be pulled off. Okay, but generally, you cannot just do what this person is. Well, we don't know. We don't know what the employer here has done, but you have to have a good reason, number one, and you must also have a procedure. Just like in dismissals, guys. Dismissals is when they're terminating the employment relationship, so they can't do that just when they want and how they want. It must be substantively. In other words, it must be a good reason. And a good reason means a reason that the law recognizes as good and fair and acceptable. And so it must be substantively fair and procedurally fair. So in this particular matter, like all unfair labor practices matters are not matters that they arise while you're working, not at the end, not only at the termination stage, but during employment, while the relationship is going on, that you have these amazing rights to call your own employer to task for treating you unfairly. So, do you think Kylie deserves to be compensated for that money she lost? Because going to the Ccma, referring about a matter, an unfair labor practice, which is unfair conduct, you could automatically, if you're unhappy with it, but the Ccma would like to see also that you've tried. But even if you haven't tried to resolve the matter, to resolve it, between yourselves, at the Ccma or any other relevant bargaining council, you would still have that opportunity to try and conciliate and mediate the dispute to come to an agreement. Okay.
I have a question, please.
Yes, you're welcome. Please.
So you just mentioned now that there has to be steps taken to try and resolve the matter before you go to the Ccma.
It is a good idea to do that, yeah. Especially with unfair labor practices and also unlawful discrimination matters.
Oh, okay.
Right?
So what
Both of
about
them.
those companies that have like an independent person who comes into, like, I think, for example, they wouldn't have just demoted the person without, well, I would like to think so. So I'll just use it as an example. So performance-wise, the person is not meeting the required standards. They have set targets. Let's say as a store manager, you need to make X amount of sales, and those X amount of sales are not happening. They go through a process of
Yes.
trying to re-equip you with the necessary skills for you to get that target. When you still don't make that target, that even after they try to mediate or try to remedy the situation before demoting you, would we still consider that as unfair? If we've
Sorry,
gone through,
can you just repeat? They go into a process. I lost you there. You said
okay, so
they
they
go into
go
a process of what?
to try and like remedy or correct whatever
Yes.
performance gaps you have as the individual before they demote you. And
Mhm.
then after they try that and that still doesn't work, you're not able to achieve the set targets that were given to you, then they decide to go to the process of demoting you. Would we still consider that as being unfair? Or
No, then I don't think that would be unfair, because now what has happened there now? Demotion, is conduct sometimes now that, it's one thing, but it can also come up at the end of it can be punitive in certain circumstances, right? So if you, like you said, if the person has been, in your example you gave here, the person is being charged for being dismissed, in this case you gave here now, that's a way of dismissing. You can dismiss people for misconduct, incapacity, or for operational requirements. So if they follow the proper procedure, they there. You there?
I lost you there for a bit.
Yeah.
Yeah. Okay. Cool. So
Yeah.
so you see, the thing is, demotion can be used as a form of punishment, as an alternative to dismissal, because ultimately it would be better to be demoted sometimes than to be dismissed.
Mm.
And you can't dismissal. You can challenge that. Then, if you are, you could challenge it, but then what would be the ground of your challenge now? That I was charged with incapacity, and there was a hearing, and the incapacity thing was that the employer looked at all options other than dismissing me.
Mm. I think that would make it difficult then to challenge.
Back again, eh? Yeah.
Yeah, you back
So
now.
in such a case, cool. So in such a case, you won't be, in my view, like the CCMA or even the Labour Court afterwards, would it were to go that way, would not would see that no, it wouldn't qualify as an unfair labour practice, because an unfair labour practice is any unfair act. So you're going to have to prove that it was unfair, right? In general case terms, you have to prove that it is, unfair also.
Okay.
And then it's going to be a bit difficult. If you can prove, look, the employer did the following things to me, right? Then the employer will have the duty to show that they've done it fairly. It's not unfair.
Okay.
Right. So let's just go back to a question. Do you think Kylie should be
I think we lost you again.
So do you think she can be reinstated?
Would it not
I think it all
depend on
depends.
why she was demoted in the first place?
Yes, because there was no reason given for the demotion. I also think that I think she should be reinstated.
Why should she be reinstated?
Because the store manager didn't give like a proper reason why it's the demotion in the first place. Is it because of poor performance, or is it because the company is having profit issues? There's no valid reason behind it.
Okay.
From my side, I think when looking at the question, it's being given in the, like, this is Kylie's side of the story. So we don't know from the company's side, obviously. So I think whether she's reinstated or not reinstated also depends on what the employer brings to the party. If the procedure, if there was fair procedure in her demotion, I don't think there will be a need for her to be reinstated. So it all depends on the case, because it can be a reinstatement or not a reinstatement. It can go either way, depending on the procedure which was followed.
Yeah, but I think what we must realize. Go ahead, yeah.
Oh no, I wanted to ask if, let's say, for example, question one was that would we compensate for the amount that was lost? Would it not be like a double reward if now we also just go give the job back or something? And what consequence would it have for the next person? So say, for example, that there was another appointment made in a place to have that role carry on. So now is there a point to having two people do the same work? So especially in that type of role. So I would look at it in both ways. Is there a consequence to me reinstating this person? And am I not double compensating the person for maybe something that they really wasn't even really unfair to begin with? But yeah, it's just my thoughts.
Are you there, guys?
Yeah, you were gone for a few seconds.
All valid points. All valid points. What I think the question is trying to make you think of and to get at is, what are the powers of the arbitrator? At the CCMA or the bargaining council. So the LRA gives the bargaining the arbitrator, if it reaches arbitration after all. Because when you go to the CCMA or to the bargaining council, you don't automatically arbitrate. You go there first to conciliate and mediate. Sometimes we do what we call con-arb, a mixture of conciliation and failing that, immediate arbitration proceedings. Then and arbitration is a different process to conciliation and mediation. And different officials at the bargaining council conduct those proceedings. And the powers that they have, at arbitration, after hearing both sides, include the power to reinstate, include the power to make any, to make a declaratory order even, to pay compensation where there was a loss. So all depends on, we again, like the other questions, and these questions have been designed in that way to make us think on both sides. We would have to see what were the reasons of the employer. If the employer had some kind of justification, reinstatement may not be possible. Right? If the employer comes out and says, well, yes, we demoted her, but she was charged for theft in a disciplinary hearing, for serious negligence, and she was found guilty of that. And we offered her that, look, when she was convicted or found guilty of the charge, that we told her, look, accept this lower position here as store supervisor rather than the manager. Okay, otherwise, if we really consider and think about it, then we may even have to dismiss you. Could be that case as well. So, but the discretion of the arbitrator is broad. If there was no reason, if the employer simply did it, and there was no justification, and there was no side of the story of the worker, of this Kylie lady, then, obviously the arbitrator will look at it differently, and the arbitrator can be moved to make an order like a severe one, which includes like reinstatement. In other words, you get your position back, 1, 2, or back pay, the difference in the back pay. Okay, so if there's no justification for it, then the employer will be in trouble. I had unfair labor practice demotion as well, about, I think, just 2 years ago. And this guy was working at an insurance company and hired at a certain level. And then they realized after a few months, that he wasn't performing well, and they just automatically put him down on a different pay scale, out informing him, no process. They just said, no, but you're not doing what you're supposed to, and and they dropped him. And then he filed a complaint and he left the place. He even left that employer, and while at the new employer now, he was still persisting with his claim for unfair labor practice. And the guy got the difference. Was that what he claimed? The difference in the payment that he had lost as a result of this unfair, where there was just arbitrary actions on the part of the employer. Any further questions on that? Because reinstatement, guys, just talking about the reinstatement. The reinstatement is a very it's a draconian, not a draconian, but it is a very it's a powerful remedy. That someone dismisses you or has done something to you, you're basically undoing what they did, to reinstate you again. And normally for dismissals, not unfair labor practices, for dismissals, the LRA says that the court or the arbitrator must order reinstatement. In fact, that is the go-to remedy, but can't order that. It says, it qualifies it. It says you can't order that if the relationship between the parties have broken down. So if the employee says, no, I don't never want to go back there again, or the employer says, no, I can't continue employing this person, the relationship is broken down, then in that case, you must not, it cannot order it, but will have to then order, something in terms of the, extra months of employment salary as a way to make up for that. But like you said, sometimes employment, reinstatement may not even be practically possible, because in the time that you've left, someone else has taken up the position, and it could make it very difficult for the employees. The employee will have to settle on the monetary amount to pay.
Makes sense.
Mm-hmm. So I also want to share something else with you here now. Some of the it was an assignment question. Did you guys do this assignment question, eh? Let me just see, you might have done it, so it might just seem that you guys did all of these questions.
Your screen is not sharing.
Not sharing?
Yes, I did that.
Hey, okay.
I can see it.
We can see
Yeah,
that.
you can see it now. It
Yeah.
takes time for some people. Okay, no problem. So have you guys done all these questions?
Yes.
Yeah.
Okay.
Definition. Yeah, we did these ones.
Okay, this is question 1 is a simple one. Question 2, this is unlawful discrimination matter. Listed and unlisted grounds, direct and indirect discrimination, it's not permitted, and what you must do. Question 3, we'll discuss the differences between an unfair labor practice in terms of the LRA, section 186, subsection 2, and the right to fair labor practices in terms of the Constitution. Let me hear your answer to this question. Who got 5 out of 5 for this question?
I did.
You did?
Yes, I
You
did.
did, huh? Well done, well done. So tell me, like, what is this? What were they looking for? The important thing is fair labor practices. Who are entitled to unfair labor practices, to remedies in terms of unfair labor practices? Who are entitled to them? To the remedies that are given where unfair labor practices are found. Who can benefit from that?
Everyone. As long
Employee.
Okay,
as
Aisha
long
says
as workers
everyone.
who are not
Okay, hold on, guys.
employees in the terms of the LRA.
Yes, not everyone, eh? So basically, only employees, as defined. Even from the very beginning, you have to make that distinction between an employee and an independent contractor for this very reason, which is okay, which is that employees get the benefits of labor, the protections afforded to them under all the labor legislation, PCA, the EEA, the LRA, but independent contractors don't get them. Now, what is the right to fair labor practices now? How's that? What is that got to do with? How is that different from an unfair labor practice? Hey guys, how is that different? Hello?
I think the Constitution covers more everyone, the labor practice in terms of Constitution, and then when it comes to the Labor Relations Act, it favors mostly the employee. So now that's what I can gather. So the Constitution is like you've got the right, everyone has the right to do this. Everyone is da 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 da. But the Labor Relations Act is more of the employee is more protected.
Right. That's the right track there. You see, because it can cause a confusion, man. The word sounds so familiar. So unfair labor practice, it's like I've repeated it this evening a few times. Section 186, subsection 2 of the LRA, it speaks at all employees. I mean, it applies to employees, and it is any unfair conduct on the part of the employer relating to promotion, demotion, loss of benefits, employee benefits or training, suspension, any conduct short of suspension, any conduct short of dismissal, protected disclosures, failing or refusing to reinstate somebody in terms of a previous agreement. These are all listed there, and they only apply to employees. But the right to fair labor practices is a far wider concept. It covers not only employees, but everybody. Hello? Hello?
Yes.
Covers everybody, not only employees. And the
We can't hear you.
I think you need to start again. You can't hear you at all now.
Okay, I think I'm back now.
Yes, we can hear you.
We're back. Yeah. So what is the classic case when it comes to labor practices? That everybody has the right to fair labor practices. That's section 23, subsection 1 of the Constitution. So what is the classic case in this regard? The courts really made you understand what this actually means. Can you remember the case of Kylie versus the Ccma? You see, Kylie was she was a prostitute, and she was being exploited. Now, can you all hear me?
Yes.
So this
Yes, you
lady,
can hear you.
Kylie, was a prostitute. She was exploited, and she was exploited because one of the requirements of a contract is that the object must be lawful. It can't be immoral, or also can't be against the law. So she was exploited. She was owed money for services and things that she did. And she took the matter to the Ccma, and they said, no, but we can't help you. You're not an employee. You're not an employee in that way, because the contract you've entered into is not valid. And this went to the Ccma and to the Constitutional Court even. And the Constitutional Court said that, you know what, everybody, although she's not an employee in terms of the LRA or the BCEA or the EEA, she's still a human being under the law, and under the wider law of the country, everybody is entitled, everyone is entitled to fair labor practices, including a person like this. So we're not going to look at what she did, but we will look at how she was treated, and she should be compensated. Not as an employee under labor legislation, but as a person considered to be under having the constitutional right to fair labor practices. Okay, so it's a much broader term, the term labor practices, fair labor practices. Okay, so you've done all of this. I've got a few exam papers that we're going to start going through, guys. But now here's an interesting thing, and this will introduce us now to dismissals, which we need to move on. I just want to see if you guys have chapter 6 of textbook. This is unit 5. Okay. And do it with the reference to that, to this question. Question 4. You also get 5 out of 5 for this question. Let's just go through it now. So X works for Exclusive Liquors as a marketing manager. One of the products made by the company is an alcoholic beverage called the Fix. So before X started working for the company, he prided himself in his teetotalism. Good. However, at functions to promote the company's products, he consumes large quantities of the Fix. The company encourages an approach of responsible drinking at functions to promote its products. It is not long before this escalates into a full-blown dependency problem for X. X starts to miss work and deadlines. The company requests him to undergo a full medical examination by the company doctor, but he refuses. He also refuses to undergo an examination at the company's expense by his own doctor. Okay. The company eventually instructs him to undergo treatment at the clinic, but on the appointed day, he does not show up at the clinic. Thereafter, the company convenes a hearing to investigate his absenteeism, advise the company regarding the requirements for a dismissal for misconduct to be substantively fair. So there's a lot of confusing questions, and it's quite a challenging question. And you know, the question is to the point. Like, you know, what's the requirements for dismissal for misconduct to be substantively fair? Did anybody get 5 out of 5 for this? Nobody got 5 out of 5. Okay. See, the thing is, man, you know,
myself and Sakani left up our hand. We both got 5 out of 5.
Oh, okay, I'm gonna go to that screen and see. Okay, good. See, the thing is, what are they trying to look for here? They asked for a simple question: what is the requirements for unfair misconduct? Right. So, is this actually misconduct, guys?
So give what we said, or
One at a time. What do you think? What did you say? Have you got your response to those?
yeah, I've got it. I just said it would depend on what are the current rules in the company. If there is a specific rule that stipulates that you need to do X, Y, and Z in the event of A, B, and C, then I don't think it was like unfair or anything. I can share the I can share the reply how I put it. So first it was just to respond.
The script, your mark. Okay.
Should I share it?
Yeah.
You are referring to this one,
Yeah.
right? So they didn't even look at the opinion or anything. They just marked the top 5 points. So I don't know how they actually go about doing their marking.
I think for what I could take out from that answers that they marked was like when we went through the 3 requirements of dismissal and we discussed misconduct. So the fact that we mentioned broker rule, the refusal, all those things were mentioned in those points. That is why they marked it like that and not took the added comments that we put in, because that already speaks to misconduct.
Okay, yeah, it's coming to me now. Yeah. Okay. You see those questions there, right? The question that they asked you was the requirements for dismissal. So for misconduct. So these are the typical questions, right? That's like textbook stuff. Any rule, you know, misconduct is any, you know, the violation of any rule in the workplace, right? Which you now do. And to be fair, to be substantively and procedurally fair, the rule must be known by everybody, right? So it must be a rule. It's published.
She's not finished. We still can't hear you.
Are we back?
We couldn't hear anything you were saying.
Yeah, no, I was also out there now, yeah. I think we are back. I'll repeat what I mean. I couldn't say what I wanted to say because I was cut out. But the thing is, the question is very simple in that it just asks you those requirements which you had to list. But now, my question is, what did this guy do that was wrong here? What was the misconduct? Which act of his would constitute misconduct?
The Labor Relations Act.
No. I'm asking about these questions now. I mean, relative to the question. Hang on, yeah. Which is like he did two things, right? He became dependent on alcohol, and then there's other things he did. He refused to go for a medical exam, and
Yes.
he was absent a lot. Now I'm asking, out of all these things, what constitutes the misconduct here? What if you were to charge him now? What would you be charging him with?
Sure. I thought that actual request was a fair request. I didn't think it was violating him in any way. So I take that the misconduct would be refusing to just do a reasonable request as an employer to say, and the intent behind it was to actually help him as opposed to looking for grounds to like dismiss him or something. I just thought the misconduct was based on that. I don't see any other really specific.
I think keeps going. Okay. So what he has done, the misconduct here is basically him refusing to go for a medical examination, right? Because you must generally obey all reasonable instructions by your employer. Right? But now, medical exams could be something else. That you can't also force an employee to go for a medical exam. It depends on the purpose, and you need his consent to do it. Coming late to work and absenteeism rather, isn't that is acceptable misconduct?
No, it's not acceptable.
It's accepted as misconduct, absenteeism.
That's right.
Yeah.
Isn't it? If you stay out of work, you think your boss is going to be happy with it.
They won't be.
They won't be, right? They're very clear about it, So if you stay out, that is an acceptable misconduct. Refusing to go for a medical exam, that is borderline because there's privacy issues, there's other things, there's employment equity. Why would you want to go? You need my consent, That could be another thing that it's borderline. It's not so clear whether that is a reasonable refusal to go. Alcohol drinking, is that an act of misconduct?
If it's excessive.
If he's drinking at work.
Because it's at the workplace.
Now, this is where this question gets hazy because he's doing his job, right? So this shouldn't be a misconduct. That can't be the misconduct. That should actually be an incapacity hearing. If he says, look, I am drunk and I have this problem because I'm doing your job, doing your work, that I've developed this dependency habit. So now you must look at ways to help me out of this problem. So many people think when people get drunk and the person has got a dependency problem, or rather when a person drinks at the job and so on, that it is a misconduct hearing. It may not always be the case. Okay? If your drug, if you're dependent on a drug or an alcohol, your employer in certain instances has a duty to help you and not just charge you with misconduct, but rather have an incapacity hearing and then also explore what what options they have to try and assist you with that problem. Okay, so if we look at the question is saying that the company convenes a hearing to investigate his absenteeism. Right, so this is also not a charge, but this is to investigate. So from the procedural point of view, they must first conclude the investigation. Right, you could have reasons for it. So when they are investigating the matter, they must find out what could be the reason. And if he comes up with a reason that, look, I'm suffering here, I've got a problem, and I developed this problem while doing your work. So the charges against him may change completely if they get to the bottom of it. Right? But the question they ask you is very simple. They could have asked you far more complicated questions. The question they asked was, what are the requirements for misconduct? And those are the standard, answers that are, regarding any rule in the workplace. And it must be, reasonable, known, consistently applied. So, okay, guys, that is our time. Please, thank you for attending. I hope you find this helpful. I want you guys, if you'd like, to make use of the request form here on the right, where you can get sessions, one-on-one sessions for those, you need, assistance with on parts of the work that you have challenges with. Okay. And if you all put your student number here in the chat box.
I put mine.
Cool.
No, I'm struggling to put my time. I'm logging in via the phone, so I don't know. I cannot send any message. So you can write it down, but I don't know what's happening on my side. I can't. I can type, but it's not sending.
Yeah, fine. Let me just put it in here. What is it?
It's 4555.
1 second. 4555.
8647.
8647.
Yes.
All right. So I shall see you guys around, and perhaps those who request sessions, they may see me earlier, chat to me earlier. Okay, I think next week we'll start with unfair dismissals proper, and we look at all the rules relating to that. Okay, and answer some questions about that as well.
So
exam questions.
Which question paper are we going to do, or is it going to be random?
Look, it's random. I've checked my records. I've got question papers going back to 2013.
Oh, okay.
So it is 2013,
random
2014. So many of them, yeah. And they can be helpful, and also from other law causes as well.
Oh, okay.
Labor law causes and other institutions, which will be helpful. And the more you do these, you see, you must be mentally ready for the exam, so you have mental memory. By the time you come to write a paper, then it's not like you have to think so hard to come up with the answer.
I think the discussions help, especially when people give different scenarios. It helps you to work through apply the theory to something, and I think that's when I tend to not forget something.
Yes. No, you're absolutely right. These things are very abstract. Legal principles and things can be so abstract. So it's helpful to be able to relate it to a practical situation. That is how you truly learn. Maybe what we can do next week is, if we have the time for another session, we can actually get who's filled in a referral form to the Ccma. Anybody did that before?
No, I've seen it, but I've never done it before.
Right. And then that will be a nice exercise to go through and then to figure out what must we do now, what's the steps, what can we expect, what must we do,
Yeah.
and that's you're on your way to practicing, labor law like that.
Sure.
Yeah. All right, people. Thank you. I shall see you next week again, eh? Or
Thank
earlier,
you.
as I say, for those of you
Yeah.
who put the form. Thank you.
Yes.
All right. Thank you.
Okay.
Bye.
Bye. Thank you.
Okay.
Bye.
Bye.
Bye.